1968 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်680 HD AHUJA and 7 others appellants vs. ဒေါ်လှယဉ် and 1 respondents ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil First Appeal before ဦးထွန်းတင် and ဦးစိန်သင် Judges HD AHUJA and 7 others appellants vs. ဒေါ်လှယဉ် and 1 respondents Partnership business deed of retirement suit on the basis of the accounts taken Arbitration Act Section 34 Filing of an application for stay of proceeding by a party to an arbitration agreement Contract Act Section 28 Exception 1 Clause 2 whether operated in view of the applicability of the specific relief act in the area where the suit had been brought Evidence Act Section 34 whether the balance sheet drawn up with the approval of the parties be treated as the basis of the plaintiff claim whether interest be allowed between the parties by a deed of partnership the deceased P.C. Ghosh now represented by the respondents was one of the partners of a partnership business by a deed of retirement the deceased agreed to retire from the business the accounts were then gone into by a qualified accountant in accordance with the agreement held the suit was based on the agreement embodied in the deed of retirement which had no reference to the arbitration clause contained in the partnership deed. The terms of the partnership deed had in effect been superseded by the deed of retirement. Moreover, no objection to the jurisdiction of the court on this score was made before the filing of the written statement by the defendant. Section 34 of the Arbitration Act contemplates filing of an application for stay of proceeding by a party to an arbitration agreement at any time before the filing of written statement. No such application had ever been filed by the defendant in this case. Regarding Clause 2 of Exception 1 to Section 28 of the Contract Act, it may be pointed out that the same was not operative in view of the applicability of the specific relief act in the area where the suit had been brought. It is therefore held that the contention that the suit was not maintainable as being premature is untenable. Held further, under Section 34 of the Evidence Act, the entires in the account book kept and prepared in the ordinary course of business by themselves do not prove the liability of a party to the suit, but the balance sheet having been drawn at with the approval of P.C. Ghosh, who had not at any time questioned its correctness, he could not be allowed to say that it was insufficient to attach liability upon him. Therefore, the trial court was justified in treating the balance sheet, basis of the plaintiff claim, to have been proved. Dogame and others vs. Sunam Ran and others, AIR 1944, Law 58, referred to. Held further, as a general rule, interest is not allowed between partners even during the continuance of the partnership unless there is an agreement or trade custom. Dipchen Golome Vest, Kishni Pai and others, AIR 1928, Sing 133 refer to U Chen Tuan Ang for the appellants, U Tin Mao for the respondents, U Sein Din Jash, the deceased PC coach, who is represented in this case by his wife and daughter, was one of the 9 partners in the firm, which carried on the partnership business in the name and style of Masa AHUJA Radio House, as well as of AHUJA Ghosh and Company. The capital of the firm was 100,000, out of which PC Ghosh contributed 26,428. It was provided by the partnership deed that the net profits and losses after payment of outgoings were to be shared by the partners in proportion to their shares in the partnership capital. By the day of retirement day, the 30th day of December 1959, which was executed by all the partners, it was recited inter alia that all the partners except M.D. AHUJA had agreed to retire from the business as from the first day of June 1959, that the said M.D. AHUJA was to continue the business as the sole continuing proprietor, that the partnership accounts were to be taken as at the 31st day of May 1959, and that the profits and losses were to be shared in accordance with the terms embodied in the partnership deed, day the 2nd March 1958. It appears that, in accordance with the aforesaid agreement, and at the instant of PC Ghosh and M.D. AHUJA, who were described as working and managing partners, respectively, the accounts were gone into by 1 A.S. Hakim, a qualified accountant, who finally prepared a balance sheet showing the total amount owned by PC Ghosh to be 29,491.83, being the account he had overdrawn and his share of contribution to the loss incurred by the partnership for the period ending 31 May 1959. It was also found out that PC Ghosh was also liable to pay income and super tax amounting in all to 19,157.90. On the basis of the accounts then taken, the plaintiff appellants filed a suit against PC Ghosh in civil regular suit number 7 of 1962 of the original site of this court for recovery of debt 51,743.92, being the aforesaid sum plus interest payable on these amounts from 31 December 1959 to 30 January 1962 at the rate of 3% per annum. The defendant PC Ghosh filed a written statement by which he denied the correctness of the amount claimed by the plaintiff and further contended that the suit against him was not maintainable inasmuch as the partnership was not registered, that the partnership still subsisted as he was compelled to sign the deed of dissolution by reasons of coercion, threat, misrepresentation, and fraud, and that the suit was also barred by limitation. None of the defense raised by the defendant found favor with the Leonard trial judge, who was of opinion that there had been dissolution of partnership consequent on the execution of the deed of retirement, and that the amounts shown in the balance sheet were proof exact that the defendant was entitled to the benefit of his share of income tax refund, which proportionately worked out to be debt 5,193.10, a decree for the sum of debt 46,173.31 only was therefore passed with proportionate costs in favor of the plaintiff, who were dissatisfied with the disallowance of their claim in respect of the sum of debt 5,193.10, prefer an appeal, while a cross-appeal was also filed by the legal representative of P.C. Ghosh as against the entire decree passed by the trial court. By consent of the learned counsel for the parties, the arguments in both cases were had together, and this judgment of ours will therefore cover both the appeals. The main grounds of appeal put forward by the legal representative of P.C. Ghosh were that the suit was not maintainable as being premature, and that no decree should have been passed without first ordering accounts to be taken between the partners of the fund. It was also contended that no interest ought to have been allowed in such a case as the present, where the partnership deed was silent regarding payment of interest on dissolution. In support of the contention that the suit was not maintainable as being premature, our attention has been invited to Clause 31 of the partnership deed, which contemplated settlement by arbitration regarding dispute between partners in respect of the matters relating to the partnership. Reference was also made to Clause 2 of Exception 1 of Section 28 of the Contract Act. This question, however, is, to our minds, hardly relevant as the suit was based on the agreement embodied in the deed of retirement, which had no reference to the arbitration clause contained in the partnership deed. The terms of the partnership deed had in effect been superseded by the deed of retirement. Moreover, no objection to the jurisdiction of the court on this score was made before the filing of the written statement by the defendant. Section 34 of the Arbitration Act contemplates filing of an application for stay of proceeding by a party to an arbitration agreement at any time before the filing of written statement. No such application had ever been filed by the defendant in this case. Regarding Clause 2 of Exception 1 to Section 28 of the Contract Act, it may be pointed out that the same was not operated in view of the applicability of the specific relief act in the area where the suit had been brought. We are accordingly of opinion that the contention that the suit was not maintainable as being premature is untenable. It was next contended that the claim of the plaintiff should not have been decreed on the basis of the balance sheet alone, and that the accounts should have been first ordered to be taken between the partners. Various rulings were presented before us as authorities for this proposition, but they all relate to cases between partners for dissolution of partnership and for accounts. Here in this case, the suit was brought on the deed of retirement, which had virtually dissolved the partnership, the deed having contemplated retirement of all the partners except one to carry on the business as the sole proprietor. The terms of the deed were admittedly agreed upon by all the partners, including P.C. Ghosh, and that it was in accordance with one of its terms that accounts had been gone into by the auditor as a Hakim, who had drawn up the balance sheet, which was not objected by P.C. Ghosh at any time before his demise. Moreover, the balance sheet was proved to have been drawn at by reference to the account book, which were accessible to all the partners, and from the evidence of S.A. Hakim, as well as of the documents found as Exhibit A and B in the record of the lower court proceeding, it was clearly made out that the balance sheet was prepared with the joint consent of P.C. Ghosh and H.D. AHUJA, another partner of the firm. No doubt, under Section 34 of the Evidence Act, the entires in the account book kept and prepared in the ordinary course of business by themselves do not prove the liability of a party to the suit, but, as pointed out by the learned trial judge, the balance sheet having been drawn at with the approval of P.C. Ghosh, who had not at any time questioned its correctness, he could not be allowed to say that it was insufficient to attach liability upon him. In this connection, we need only to reiterate the ruling in the case of Dugame and others vs. Sunam Ran and others 1, cited by the lower court, where the following observations were made. The partnership account book being accessible to all the partners and being kept more or less under the surveillance of them all are prima facie evidence against each of them, and therefore also for any of them against the others. Consequently, in a suit by some of the partners against the others, it is not open to the defendants to ask that the partnership account book relied on by the plaintiff be formally proved, or to contend that they were not prima facie evidence against them. For the reason set out above, we would hold that the trial court was justified in treating the balance sheet basis of the plaintiff claim to have been proved, however, in allowing the claim of the plaintiff in respect of the sum of Jet 3,094.19 as interest, we are of opinion that the trial court order cannot be sustained. As a general rule, interest is not allowed between partners even during the continuance of the partnership, unless there is an agreement or trade custom. We are fortified in this view by the ruling in the case of Dipchen Golome vs. Kishnibai and others 2, where it was held that although interest is payable to a partner on money paid or advanced by the partner for partnership purpose beyond the capital he has agreed to subscribe, as a general rule, interest should not be allowed between partners unless there is an agreement or trade custom. No such agreement was incorporated in the deed of retirement, and there is nothing on record of the lower court in proof of the circumstances which would entitle the plaintiff to claim interest as against their erstwhile partner P.C. Ghosh. Moreover, the interest claim was in respect of the period subsequent to the dissolution of the partnership. We would therefore hold that the claim of the plaintiff regarding interest should be disallowed. The plaintiff claim included the amounts payable by P.C. Ghosh on account of income and super tax. It was common ground that there had been a refund of debt 19,650.12, which was not taken into consideration when the balance sheet was drawn up. The learned trial judge therefore held that as the firm was benefited by the refund, P.C. Ghosh was entitled to have debt 5,193.10, his proportionate share, to be deducted from his total liabilities. The learned counsel for the plaintiff, however, contended that the income and super tax were paid out of monies borrowed by the fund, and as such, P.C. Ghosh was not entitled to the benefit of the refund. We are unable to follow the line of contention put forward by the learned counsel. The amounts due in respect of the income and super tax, from whatever source the same had been paid, had been debited to the account of P.C. Ghosh, and it would be inequitable to hold that he was not entitled to be benefited by it. We are therefore of opinion that the trial court was correct in allowing P.C. Ghosh to enjoy his proportionate share of the refund of income tax. In the result, we would hold that the plaintiffs are entitled to a degree for debt 46,173.31 minus debt 3,094.19 equal to debt 43,079.12 only. We would accordingly modify the decree passed by the lower court with proportionate cost thereof. For the reason given in our judgment day, the day of December 1967, this appeal is dismissed with cost.